A wrongful death case springs from a negligence claim of some type. It can be an intentional action that's caused a wrongful death as well, but most of what we talk to folks about are deaths that occur as a result of negligence. In the state of Missouri, when someone dies as a result of negligence, no matter what kind it is, whether it's medical negligence, negligence on somebody's property, negligence because of a product, negligence because of a car wreck of some type, when that happens in this state, if you are a surviving spouse, parent, or natural or adopted child, you have a right to bring a wrongful death claim. And the proof on the wrongful death claim is the same proof that would exist if the person hadn't died and instead had survived it and had an injury claim. So the fault part, the negligence leading to an injury, leading in a death claim to the person's death, is the same. The difference is that the person's bringing the claim and the harm that's being considered is the survivor's harm. So obviously all of us have loved ones, and if we lose a loved one, it's the loss that we suffer by not having that loved one here anymore that is part of what is being considered in damages. Our state in Missouri has a statute in place that lays out a list of categories of what one can make a claim for when they've lost a loved one. Now, there's the economic part, which is the same as the injury claims, the medical bills, the lost earnings, the lost value of household services that person brought into the home, funeral expenses, the economic part, which is pretty easy to get a handle on of what that damage value would be. The non-economic part is a value placed on the companionship, the comfort, the care, the concern, the emotional support, the guidance, counsel, and training that one provides to their loved one. In Missouri, there's no claim for grief and bereavement. In Oklahoma, there is. In Missouri, there's no value being placed on the life itself that was lost. In Arkansas, there is. So there's varying ways that each of the states around us analyze how to make a wrongful death claim and what's the damages that are being claimed. But ultimately what exists is a claim can be brought. In Missouri, it can be any one of those people, parent, spouse, or child. In Arkansas, a representative of the estate essentially is appointed. In Missouri or Oklahoma, it can be what's called a survivor at law, meaning that you have somebody that is ordinarily a spouse or a child or a parent, one of those, bring the claim on behalf of the rest of the folks that lost the loved one. And when that claim is brought, there's the ability to prove the harm that each of the survivors have. But one other thing, if that person that was lost lived for a period of time after their injury that was caused by somebody's negligence, then their damages survive them through the people bringing the claim. That's what we call survivorship damages. So if, for instance, you have a situation where somebody's in a bad trucking accident and they have serious brain injuries or spinal cord injuries, or they're bleeding internally, and they go to the hospital and they go through surgeries and they live for 30 days afterwards, and then they pass away. Then all of that time that they lived from those injuries, that pain and suffering, that impact on their enjoyment of life, that harm, a value for that, survives them through the person bringing the wrongful death claim. One other category of these that's important to consider. Sometimes the proof is that the death was likely going to occur anyway, even though the negligence sped it along. Okay, so let's take an example. Let's say somebody has cancer, and by the time it's caught and diagnosed and treated, it's already metastasized, spread to some part of the body, and they're not able to survive. If there has been warning signs of that in advance that are not heeded, and there's been a failure to diagnose and treat that cancer, then there may be a claim associated with that person's loss. But if the proof is that the chances of surviving that particular cancer were only 40%, let's say, then the law allows for what's called a lost chance of survival claim to be brought, even if you can't prove that more likely than not the person would have lived but for the negligent action. So in a wrongful death claim, you're having to prove that more likely than not a person would have lived but for the negligent action of whoever was being negligent. In a lost chance of survival claim, experts are having to look at it and say, I can't say more likely than not that person would have lived, but that person lost a 30% chance of survival or a 40% chance of survival. And so there is a claim for what's called a lost chance of survival that will exist even if the proof is that the person would have likely died anyway from whatever the problem was that they had. That's essentially what's part of a wrongful death claim.